Welcome to Ethics and Developmental Disabilities.
Lecture 3, Human Rights Legislation.
The Canadian Human Rights Act prohibits discrimination based on race, ethnic origin, gender, sexual orientation, age, or disability. Does this mean that no discrimination takes place in Canada? Complete the organ recipient exercise. Since you are only allowed to select one recipient for a lung transplant, you are forced to discriminate against two other potential recipients. Email the ranking of the candidates to the course professor using the subject, the organ recipient. The Canadian Human Rights Act covers all federal services such as banks, railways, airlines, and crown corporations such as post offices. Plaintiffs must file a claim to the Canadian Human Rights Commission. The Human Rights Commission will appoint an investigator to determine if the complaint is valid. The legal term for a valid complaint is bona fide. As the goal of human rights decisions is to correct wrongs against the community, compensation is limited to a maximum of $50,000. The Ontario Human Rights Code prohibits discrimination based on numerous characteristics, including disability. This legislation is extremely important as most services and businesses, which are a source of discrimination, are under provincial jurisdiction. The legislation governs both private and public services. Education, hospitals, social assistance, accommodation, and private employers are just some of the areas covered by the Ontario Human Rights Code. Plaintiffs must file a claim to the Ontario Human Rights Commission. The Commission will appoint an investigator to determine whether the complaint is bona fide. Consider this video clip that highlights a discrimination case that was adjudicated by the British Columbia Human Rights Commission.
In 1981, Jerry and some friends with developmental disabilities set out to get a bite to eat.
Look, we're just too full right now.
What do you mean? You won't serve us?
We're full.
Jerry knew what was going on, so they took the restaurant to court and won. Why did Jerry do it? Did he want revenge? To teach them a lesson?
No, I just wanted a clubhouse and fry.
If the complaint is bona fide, the plaintiff can be compensated for personal expenses incurred while making the claim. The offending party can be asked to change its discriminating procedures, and the plaintiff can be compensated to a maximum of $25,000. Consider the case of Connie Hines versus Christian Horizons. Connie was an employee for Christian Horizons for 2 years when she disclosed that she was gay. The organization harassed her and threatened to dismiss her, citing a lifestyle agreement she signed when she was initially hired. Connie won her case, and Christian Horizons was required to pay her for the pain and suffering she incurred. She was also compensated for her expenses associated with making her claim and the 18 months of salary she lost while her claim was being heard. Christian Horizons could no longer require staff to sign a lifestyle agreement and could not make lack of faith or sexual orientation a barrier to employment. Further, Christian Horizons staff were required to attend sensitivity training. The Canadian Charter of Rights and Freedom states that everyone is equal before the law and entitled to the same treatment under the law regardless of disability. Consider the following video clip, which features the commentary of Seth Jones, a disabled activist, on the community's attempt to pass a bylaw forbidding the establishment of a group home.
In 1999, outside of liberal New York City, a group home was planned to open for developmentally disabled. A town meeting was called to deny this plan. 600 people showed up. The following are quotes from some of these people. "We are appalled that this home is less than 1/4 of a mile from an elementary school. Another person states, I have nothing against the disabled. I'm against a group home opening in my community. The Homeowners Association made this statement. We of the Homeowners Association will defend our purpose for better community living with a plea to deny the group home from opening. And lastly, we in the community are fearful for the safety of our children and the effects to our property values. How do I feel about that? I think they're f***ing.
We are sorry for this interruption. The network has censored this portion of Seth's commentary due to really, really bad language. We can now continue.
That's how I feel about that. Thank you.
The Canadian Charter of Rights and Freedoms covers laws enacted by federal, provincial, and municipal governments. No laws can be enacted that discriminate against any group, including the disabled. Plaintiffs must file a claim to a federal or provincial Supreme Court. Discrimination tends to be associated with three broad areas: denial of service, refusal to employ, or expulsion. There are many factors that make proving discrimination difficult. First, one must claim immediately. It is often difficult to get witnesses. People are reluctant to put any discrimination actions into writing. Discrimination may be the action of one person and does not represent a systematic practice and thus would not be a bona fide discriminatory action. It requires a significant time commitment on the part of the plaintiff. While lawyers may not be required, there may be personal expenses associated with the claim, and it may be difficult to identify the right jurisdiction. You should now complete the right jurisdiction exercise. Once you have completed the exercise, email your answers to the course professor using the subject, the right jurisdiction. Civil law involves reparation for physical, economic, or emotional injury. Consider this enthusiastic commercial by Burger and Green to recruit clients for civil actions.
Severely hurt? No matter how you were hurt, you may be entitled to cash from several insurance sources. Everyone to blame may owe you money. Talk to us about how much your case may be worth. Call me right away. 1-800-999-2626. I'm Larry Green of Burger and Green. If you have scars, broken bones, burns, paralysis, I'll battle to get you every dollar. All the money damages the law allows. Burger and Green. 1-800-999-2626.
Civil law involves compensation for the victim. It requires an immediate record of written facts. Civil law tends to be expensive. 95% of civil law cases settle before a judgment is rendered. Consider the class action suit brought against the province of Ontario by David McKillop, a resident of Rideau Regional Centre. David alleged that the staff physically, emotionally, and sexually abused him while he was a resident at Rideau Regional Centre. The province settled. Ex-residents of Rideau Regional Centre are eligible for compensation of $2,000 to $35,000, a one-time payout depending on the severity of their abuse.
With his wife Eileen by his side, 60-year-old David McKillop says he has a great life now. For years, though, he says he was living a nightmare.
Like a prison camp.
Like a prison camp.
That prison camp, McKillop says, was the Rideau Regional Centre in Smiths Falls. McKillop says it was there that he and hundreds of others endured decades of physical and sexual abuse.
Well, when I was 8-year-old, I got beaten up by staff. Head to toe, black and blue. And I got kicked in the groin. That's why I can't have kids. And I got sexual assault.
McKillop says the Ontario government knew about the abuse but looked away. So he's launched a class action lawsuit looking for $1 billion in compensation for alleged victims.
As a family member, you had great trust in what was told to you.
Vicki Clark says her brother Rob was also a victim of abuse.
People may think because all the big facilities are closed and institutions that this kind of stuff won't happen again, but we still need to be vigilant.
And it's not just Rideau Regional. Former residents of the Huronia Regional Center near Orillia also claim abuse, and they too have launched a class action lawsuit. David McKillop says what he wants is simple.
I want the government to say sorry what happened.
For this lecture, you should be able to answer the following questions. Distinguish between the Canadian Human Rights Act, the Canadian Charter of Rights and Freedoms, and the Ontario Human Rights Code. Be able to identify which area of jurisdiction you would approach in the case of a discriminatory action. And list and briefly describe 3 barriers to proving discrimination. Consider the following video clip, which highlights a class action suit that was brought against the province of Alberta for the wrongful sterilization of Leilani Muir.
They don't call this process a trial for nothing.
Morning. Fine, thank you.
It's a very demanding thing for you to go through.
So what did this court case mean for you today?
Hoping it's not still happening somewhere else in the world. Nobody has the right to play God with other people's lives.
It is going to be a physically draining process, and it's going to be an emotionally draining process.
What would your life have been like if you'd never been sent to that school, if you'd never been sterilized?
I don't know. Probably a heck of a lot better than it has been.
Okay, we were trying to get a handle on...
In 1957, as a girl of 14, Leilani was surgically sterilized in the provincial training school for mental defectives. Now, she's suing the government of Alberta for damages. After years of preparation, her case goes to court in just a few days.
Is that right?
Yes.
Yeah, okay.
Yeah.
This is going to be a 3-week process. That you're going to be there, you're going to be in the courtroom, and you're going to be watched and scrutinized during that whole time.
The lawyers for the other side are going to want to go through that story from their own perspective, and that will be done under cross-examination of you. How many children you would have had? I mean, did the numbers stay constant, or
no?
There's no turning back for Leilani now. But the journey here hasn't been an easy one. It's taken her back almost half a century to a sad little girl in rural Alberta.
Well, my earliest recollection is living on the farm, not really having a childhood for the way my mother treated me, the beatings that my mother gave me, starvation. I used to steal lunches, take lunches from the other kids. I'd go into the lockers, or if they were hanging up, I'd take sandwiches and stuff out of their lunches, because I wasn't getting a lunch to take to school with me. And I had to eat. And eventually the teachers saw this, and they would start bringing lunches for me. And whenever the teachers or anybody tried to question my parents about it, we'd move. When I think about it now, a lot of people didn't know my mother had a daughter, because I was always locked away, hidden away, locked away, whatever. Being on a farm and you're not close to neighbors, it's pretty easy to hide you away. I was let out of the car. No one else got out. A nurse met me at the bottom of the steps and took me upstairs. I just thought it was an orphanage because I had already been in convents before. So to me, it was just another place to be with young girls where I could enjoy myself, play with toys, and have a bed, clean bed actually, and clean clothes, and 3 meals a day. Go to school and get outside and play. Kick butt if I felt like it.
Harold Barnes was a boy of 13 when he was sent to the Michener Center in Red Deer.
October the 8th, 1964, I was admitted to Pineville at 2:15. It's the first time I ever was away from my parents.
Ken Nelson was just 8 years old and a ward of the province when he made the same journey.
I can remember Roger, Brent, and myself. We were going for a ride. We were told by the person who was looking after us at the Alberta Protestant Home here in Edmonton, and they had informed us that the 3 of us were going to live someplace else in Red Deer.
I was coming to the Michener Center because I had polio, and I was a very young girl.
Rita Haggerty was confined to the same institution almost 70 years ago.
That's where the government put me.
My mother never wanted any girls, and she had told me that. So she had found a place that would take me. She had to do a lot of lying to get them to take me, but she did it.
After all those years, finally, the day of reckoning has arrived.
Sure.
Can you tell us what's happening this morning?
Well, the trial is going to start at 10 o'clock in courtroom 414, and of course, Ms. Muir is very happy that she's going to have the chance to tell her story in court.
I want a public apology. That is something, and I want the public to know absolutely everything that we possibly can, what happened in the institution.
I think the fundamental issue is whether or not she was properly confined in an Alberta government institution and whether or not she was properly sterilized by the government.
Yes, I want compensation for it. You cannot put a price on a child's life, and you can't put a price on what they took away from me as a woman. You can transplant hearts, kidneys, now, but you cannot give a woman her tubes back.
This is the first case that's gone to trial.
The other one's
concerning
out of
these
court
issues.
settlements?
I believe that one previous claim was settled out of court.
For the plaintiff, John Falls. My lady, on July the 12th, 1955, a few days before her 11th birthday, Leilani Muir was admitted to the Provincial Training School at Red Deer, Alberta. The evidence will show that in November of 1957, a single IQ test was administered after 2 years.
Down. If I'd have settled, they would have said that was hush money. And people would not have known to this day what really happened in Canada, which should never have happened.
The first witness will be Miss Leilani Muir. Question: can you describe when it was that you first became aware that you were going to be taken to the Provincial Training School? Answer: when I was dropped off there. Question: do you remember anybody giving you any kind of tests or examination besides examining your body? Answer: no. Question: what do you remember about the admission process? Answer: only being taken over to the Ash ward.
None of us girls, well, I don't remember ever talking about stuff like that, why they were there. Because I just thought, well, they were there the same reason I am. Nobody wanted them. But they were just like myself. We could fight, we'd get along with each other, pull each other's hair when we were little if we got mad, and pillow fights and whatever. We had a good time, you know. We were like sisters.
I saw numerous people like myself who did not belong there, who should have never have been there. So one has to ask yourself, how did so many people end up in that situation?
You put a child in an institution, then shut the door and not come back for a long time. That child in mind and body is destroyed.
For the plaintiff, John Falls. Question: do you remember being sent to other villas? Answer: if we were punished. Question: what were those other villas like? Answer: they had people in straitjackets, and you were put in a little tiny room with a rubber mattress, and it was cement all around, and a little tiny window in the door.
Each time I tried to get out or to try to get help to get out, I was put in the side room. If I refused to clean up human waste, I was put in the side room.
We were never convicted of any crime, but you almost felt as though you were a prisoner, that you had no rights. Those rights were taken away from you.
For the plaintiff, Sandra Anderson. Question: and what is an orchidectomy, Dr. Thompson? Answer: it is the removal of a testy. Do you know why Dr. Parsons would be performing an orchidectomy? No, I don't know at all. There are many possible reasons, which are medical reasons.
Perhaps the most flagrant violation was the case of approximately 30 young men in the 1950s who were ordered to undergo testicular biopsy, which is not an operation for sterilization. These young men had Down syndrome, and it's known, and it had been known since the 1940s, and the Eugenics Board knew it since the 1940s, because it's in their records, that male Down syndrome individuals are infertile, so that sterilization was totally unnecessary. And yet they not only permitted, but they authorized sterilization of these individuals, and for purposes of research for one of their members, as well as for the medical superintendent of the provincial training school.
When I heard on the stand about people being castrated and them using their parts as experiments, that angered me to the point where I just, if I could have jumped over that and did something, I would have, but I know I would have gotten thrown out of the court.
I guess we got it set up here.
On January 25th, 1996, Leilani Muir was awarded close to $750,000.
We think this is an award that recognizes the depth of the injury that Ms. Muir has suffered, and it recognizes the depth of the wrong that was done to her when she was sterilized in 1959 and confined in the provincial training school for 10 years. And we hope that this is the end of that struggle for Ms. Muir. I think it is